All right, hello. I hope everyone can hear me. This is Greg Fletcher. I've been with Bradford Barthel for 16 years, and before that, I was in-house with a very large insurance company doing workers' compensation defense for 6.5 years. So I've basically been doing this for about 25 years, and have drafted many, many settlement documents. So I'm very familiar with it. I've seen good ones, bad ones, and indifferent ones. So without further ado, let's go into compromise and release. When do we settle by a compromise and release? When we're off the risk, when we wish to settle future medical care, when a claim or a right to benefits is disputed. Now, what is a compromise and release? Typically, it is a settlement in a single lump sum. We agree to pay a certain amount of money. We don't typically differentiate, although the new documents do divide up what benefits have been provided and what's going to be paid. Advantages of the compromise and release are that it generally resolves all issues. There is no right to reopen once the settlement has been approved, and issues such as penalties can be resolved without admission or fault or liability. And in fact, in a compromise and release, nothing is admitted. You can settle without admitting even that an injury occurred. When do you not settle by compromise and release? Typically, if you're still on the risk because you don't want to pay, for example, for future medical care and then have your injured worker file a new claim and end up having to pay a duplicate settlement of future medical care for the same body part. So if someone is still working for your insured and you're still on the risk, you typically would want to leave medical care open. A compromise and release can only be entered into by agreement. So if either party is unwilling to settle future medical care, then you're not going to be able to settle. Applicants are often concerned about their ability to pay for future medical care, and they don't want to buy it out. Often these days, defendants are concerned about funding exorbitantly high Medicare set-asides and don't want to settle future medical care. Usually don't feel that it's worth it when the allocation analysis comes back very high. Occasionally, there'll be a third party that will object to a compromise and release. This really doesn't happen very often. I have seen the Death Without Dependents unit object to settlements, calling them a sham settlement when they think that the money should be paid, the death benefit should be paid to the state, and we have found in the woodwork a dependent and fought them off for a nominal amount. Sometimes co-defendants object, but they really don't have standing in most cases to prevent you from settling your case. Benefits which can be settled by compromise and release are almost everything that's out there in workers' comp: temporary total disability, temporary partial disability or wage loss, permanent disability, life pension, future medical care, out-of-pocket medical expenses, penalties, interest on delayed payments, vocational rehabilitation, and we don't have that anymore, but if for some reason there was an issue, it can certainly be settled. In the old system, you couldn't settle it without a Thomas finding. There were some changes, and again, it's pretty much gone. Supplemental job displacement benefits, which replaced vocational rehabilitation up until January 1st, 2013, at the dates of injury. We could settle the voucher. Now, by statute, we can't settle the voucher. What cannot be settled by compromise and release? Claims over which the Workers' Compensation Appeals Board has no jurisdiction. Oh, I'm hearing that you're not hearing me too well. How about that? Is that better? Email us and let us know how we're doing. All right. The WCAB is not going to approve settlements over which they have no jurisdiction. For example, civil claims, FEHA, that's Fair Employment and Housing Act claims, Americans with Disability Act claims. These are claims that are either in the jurisdiction of the state civil courts or the federal government, and the Workers' Comp Appeals Board is not going to settle those claims in your C&R. Retirement issues. A third-party C&R will settle a civil settlement, but that is a hybrid. It's a civil settlement and a comp settlement. The WCAB is only approving the comp part of that settlement, technically. Unknown claims. Back in the old days, we would have addenda that would say this settles all claims, known or unknown. The Workers' Compensation Appeals Board typically will not approve those addenda to claims. They'll ask you to strike that language. And again, vocational rehabilitation, traditionally we could not settle it without a Thomas. Now the voucher for injuries on or after 1/113, settlement of that is prohibited. Again, this is the site for the Thomas case. It really is an anachronism because we don't have voc rehab anymore. People still put it in their settlements because they use it as leverage with lien claimants, but you can also do that with other language. Again, we have a statutory prohibition. That's the site there at the bottom of the slide, Labor Code Section 4658.7G. The question is, do we have a Thomas for the voucher? We probably never know because the vouchers are just not that high in terms of the value. That's $6,000 for each one, and it's probably never going to go up to the Court of Appeals, so we won't have a published case on that. But I can see a situation in which you essentially allege something akin to a Thomas, which is a good faith dispute that would defeat applicant's claim. I've seen attorneys at the board arguing that there's a dispute over whether applicant is eligible for the voucher, so they should be allowed to settle it. They've been shot down by the judges that I've seen. In fact, one judge in Sacramento said that judges have been disciplined for approving settlements of the vouchers for injuries after January 1st, 2013. How many times do the vouchers get used? Very rarely, probably not worth fighting about. So when should you first think about settlement? Of course, we all get this drummed into our heads. You should be thinking about it early in the case. Don't wait till the injured worker is permanent and stationary or MMI for every body part. Even if the claim is denied, you then think nuisance value. Really, at every stage in claims handling, you should be thinking, what is my value? If I were to try and settle this case today, what would it take? Now, often, it would take more than you're willing to pay, and you need to work through the process and develop the record and so forth. But there are many times when there's an opportunity, and what it would take to settle the case is right in line with your valuation, and you can shut the case down. Everyone knows that a closed file is a happy file. Hurdles to settlement. Of course, the injured worker may not take what you're offering, may not be interested. They may be worried about malpractice. They may want to wait till everything's been worked up so that they are comfortable with the settlement value. The applicant's attorney, same thing. They may be reluctant to recommend to their client that the case settle for whatever you think the value is. Obviously, you need to get approval by the Workers' Compensation Appeals Board. The INA officers get involved when you have injured workers that are unrepresented, and sometimes backseat drive with respect to your settlements, and then you have problems and you can't settle for what you thought the case was worth. My rule, this is Fletcher's rule, is that a compromise and release is less about the numbers and more about who wants it more. If you're very motivated to settle, you will be paying more money. If applicant is very motivated to settle and needs the money, they will take less money. So sometimes it's really about the numbers and not so much about the issues. But neither side can be forced to settle by compromise and release. It has to be an agreement. Valuing cases is really outside the scope of this seminar, this webinar. It's really about just the mechanics of drafting the documents. But the key is to do a cost-benefit analysis regarding each issue, come up with a value, and then you have a total value when you add that all up. Look at what you would concede, what you would litigate, what the cost of litigation is, what the potential outcomes are. Identify areas of agreement and areas of dispute. Weigh arguments of each party in order to weigh the issues. If you have a 10% chance of winning, then maybe the value is 10% of whatever the issue is. Every settlement has to be approved by a workers' compensation administrative law judge. This is Labor Code Section 5001. Also, Board Rule 10882 directs the Appeals Board to inquire into the adequacy of the compromise and release. This is where we get the board's authority to second-guess your settlement. In a civil case, the parties agree. It can be for $1. You just notify the court that the case is being dismissed because there's a settlement. They don't even look at it. They just dismiss the case. Workers' compensation, judges are charged with the duty of overseeing that settlement. It's very patronizing, and they have to be sure that the injured worker is being treated fairly. Now the question is, does this mean the injured worker gets every possible benefit under the record you've developed? The answer is no. The settlement only has to be within the range of potential outcomes to be adequate. Board Rule 10870 provides that agreements which provide for the payment of less than the full amount of compensation due or to become due, and which undertake to release the employer from all future liability, will be approved only where it appears that a reasonable doubt exists as to the rights of the parties or that approval is in the best interest of the party. What does that mean? What it means is what we just said, which is if there's a range of possible outcomes on the record and the settlement is within that range, then it's adequate. If the best case for the defense is 0, you owe nothing, and the worst case for the applicant is their permanent totaling, they owe 100%, really the settlement that's anywhere in that range would technically be reasonable. Now, we all know that if you're settling for $10 in that circumstance, the judge is going to quiz you as to what are the real potential outcomes and probably not find it adequate. So you have to get a feel for what the board is going to view as adequate given various ranges of outcomes and various issues. The tools used by the Workers' Compensation Administrative Law Judge to assess adequacy, the DEU. Often a judge will say, has the DEU rated this report? They want to know what the DEU says the permanent disability is worth, and they're comfortable if that's what you're settling at. Also, the Information and Assistance Officer. In the old days, and I don't know if this is as true now, every settlement with a pro per would go to the Information and Assistance Officer, and they would provide a little report to the judge as to what they thought of that settlement. That gives them tremendous power to recommend or to give a thumbs down to a potential settlement. However, they can also be your friend. The Information and Assistance Officer can be used to help educate injured workers who have very unrealistic ideas about what they can get in workers' comp and pull them back down to what the law is providing in terms of the benefits that are really owed to them. And often, if you have a conference with the INA officer and the judge, after that conference, you'll have a settlement that the injured worker will be comfortable taking because it's not just your word that it's adequate, but they're being told by the board that this is what the law provides. What are your tools to establish the adequacy of your settlement? Well, it starts with our webinar today. After the webinar, you will have superior skill in drafting the compromise and release. And really, this is the case. You have experience drafting a lot of these things, having them reviewed by judges. You kind of know where the edges are, what you can get away with, what's going to be a problem, what you're going to need to explain, what is self-explanatory. You also have supporting documents you can provide. I can't emphasize this enough. If there's something in question and you have documents in your file that shows why you came to a certain conclusion, for example, earnings, and you have a wage statement that shows those earnings, provide that along with the settlement. The judge may or may not look at it, but the fact that you provided it shows that you have documented what you've done. And often I will simply tell the judge, I have a wage statement and it supports X as the average weekly wage, and they'll take my word for it because of my credibility at the board. But the fact that I have that, I've gotten it from my client, is tremendously important and really valuable for me in being able to establish to the judge that we've done our homework, that we're not just pulling these numbers out. It's not something someone told us. We have documentation for what we're doing. Explaining the basis of the settlement, and that's what we're going to get into in this webinar today, is how do you explain in the briefest manner with the least amount of documentation, but what's necessary, what the basis of your settlement is so the judge knows that it is adequate. When you submit the settlement, a judge can only do certain things. The judge can approve it, can suspend or make inquiries regarding the basis of the settlement or missing documents. You'll get these letters saying, action on your compromise and release is suspended. Please answer the following questions or please provide the following documents. The judge can also just on their own set the issue for an adequacy hearing and have everyone show up and then go over the settlement and see whether it's adequate or not. It gives you an opportunity to explain the basis of the settlement, and if it really is not adequate, to provide additional authority. Or the judge can simply disapprove the settlement. What the judge cannot do is make unilateral changes to settlement documents, and that is there's a couple of cases there. Once again, you can find this PowerPoint online, so I'm not going to necessarily read every site. If you want to go back and get those sites, you can certainly pull that from the PowerPoint presentation that's on our website. But if you see a judge making changes to your settlement, that needs to be appealed or objected to in some fashion. They do not have the power to do that. They can either approve it, suspend it, set it on adequacy, or disapprove it. All right, now we're getting into the actual form. The compromise and release form is provided. It is a regulation, and it's provided by the DWC. If you don't know where to find it, go to the DWC website. They have the forms. Unfortunately, they're not really fillable. they may be fillable, but they won't remember them, so it's very difficult to save them on the DWC website. But all the forms are there. There are a couple of compromise and release forms that are outside the scope of our webinar today. The death and dependency claim form and the third-party compromise and release. Those are kind of special animals because those settlements are a little different. So I'm not going to get into those today. If you have questions about those forms, you can ask me, but the forms should be on the DWC website or at the board. The board has copies of all the forms. All right, page 1 of the form, and we're going to go back and forth between the actual form itself and the slides that explain what to do. So there may be a little repetition here, but you include all the case numbers, applicant social security number. This is all sort of administrative aspects of the claim. The venue, usually it's based on applicant's attorney's office or applicant's residence, but you need to provide the venue. You don't want to file your settlement in the wrong venue. And I usually let the applicant or the applicant's attorney fill in applicant's address so that it's on them to provide us with the correct address. Then you need to pay attention to what they put on there, send your check to that address, and then they can't complain that the check went to the wrong place. Often applicants bounce around. We don't always know where they are. If we rely on our information and it goes to the wrong place, it's probably not a penalty if they didn't update the board with an official change of address, but it causes problems, and why not prevent those problems? Let them fill that part out. Provide the employer name and address. These days with EAMS, if you're an e-filer and you get into EAMS and the information in your settlement doesn't line up with the information in EAMS, then EAMS starts rejecting it. So sometimes these things have to be cleaned up. The appropriate name of the employer, applicant's date of birth, all kinds of things can be different in EAMS than they are in your file, and then you need to determine the best way to make that consistent so that EAMS will accept your settlement if you're e-filing it. Also, with regard to insurance coverage, under the cold iron case, which the site is down at the bottom, you can be sanctioned if you improperly identify the principal who's responsible for payment. I think that case has been taken quite a bit farther than it was actually intended. In that case, the defendant who was incorrectly identifying his principal was actually representing SIGA, and as we all know, there are special rules with SIGA. It dramatically changed the liability of the other parties, and so that individual was sanctioned for not identifying that information earlier in the case. I think in most cases it doesn't matter, but the judges are very concerned that the name on the settlement is the party that's going to have to pay so that there isn't any problem with getting payment or enforcing it. So it is important to be accurate in identifying who the carrier is. All right, here's the page itself. It's basically got all the information that we just went over. Case numbers are at the top. Over there at the top of the bottom column in the top right section is the applicant's social security number. Next is the venue section. The next section is the employee information. I would put the name, of course, but leave the address blank. And then the employer is next. The form, page 2, has applicant attorney and defense attorney information. If you don't have representation of either party, you can leave those blank. Insurance company. Note that if you're a TPA and the insurance administrator is the next page or the next section, so keep straight whether it's insurance or whether it's a TPA, and if the employer really is self-insured, then of course accurately represent that and provide the claims administrator. So here is page 2. We've got applicant's attorney at the top, defense attorney in the middle, and insurance carrier, which again we need to distinguish from a TPA, which is on the next page. This is again repeated. Interestingly enough, in a lot of my settlements, I don't have the insurance carrier's information. I have the TPA, I have a good caption, I know who the carrier is, but all of my dealings are through the TPA. I often use the same address, which is typically a P.O. box, for the carrier that I'm using for the TPA, and I have never been challenged with this. You probably have more accurate information than I have about the address of your actual carrier, so that may not be a problem for you, but if you don't, you can use your TPA address as the address for the carrier, and I have never had anyone challenge this or try and find out what the actual address is if there's something different. The claim information, this is where you're starting to get into the actual description of the claim, and the claimant, again, date of birth. Often it's different in EAMS than it is in our file, and you have to make sure it's consistent. Sometimes we go into EAMS and correct it. Sometimes we even have to have applicant's attorney file an amended application. So it's easy to check that stuff and make sure that it's consistent before you're down at the board or before you're trying to submit it to EAMS to do a walkthrough the next day. Occupation, this is often in dispute. It's perfectly acceptable to write in dispute. In fact, in the old days, we used to put in dispute on almost every box. But these days, the judges, particularly here in Sacramento, and probably in a lot of the Northern California boards, will ask, what is the nature of the dispute? What is the applicant saying? What is defense saying? What's the difference? What are you paying to resolve that dispute? You suddenly open the door for the judge to ask you why you're not paying more money to resolve this dispute. So if everyone agrees on the occupation, just put it in, whatever it is. I typically put in what my employer describes the occupation as, and very rarely do I have applicant's attorney or applicant challenge that. Also, supporting that the compromise and release is an award of a specific permanent disability rating for purposes of future apportionment is something that we're trying to do. It's been a long time since the case came out that said a C&R is not an award of PD. But we still hope that someday when we put our rating in the C&R, it will be determined to be an award and we'll be able to use that for apportionment. For those of you who know about Labor Code Section 4664, it provides for apportionment if there's been a prior award. But a C&R was taken out of the definition of an award, and so therefore with a prior C&R, we don't get that apportionment. Although the case says a rating without more is not an award, and what is more? Is a rating in the C&R more? One would hope that would be because we spelled out the rating. All right, here's the form, page 3. Again, claims administrator is the TPA, and then we're into the information about the injured worker and about the claim, date of birth, occupation, and then we get into various injuries because we can settle more than one injury with the C&R. What I've given is an example of a specific injury here. The start date is the date of the specific injury. You notice there's a line that says end date. That would be if you check the box marked cumulative trauma. I have listed a bunch of body parts and the codes for those body parts. And then the injury occurs at, typically it's at a job site. This is something that they're not real sticklers for. You don't need an actual address. You can just give a basic description of that. All right, we're trying to adjust the mic here so we can hear it better, and keep giving us feedback, so we'll keep trying to do that. I understand I'm a little hard to hear. All right, moving on to the next page. This is a cumulative trauma example. You'll note that we check the box marked cumulative trauma. We provide a start date and an end date. It doesn't have to be a year. The year is a creation of statute. It's a one-year liability period. The actual injurious exposure could have happened over 3 weeks or it could have happened over 20 years. But typically when applicants' attorneys file these things in the application, they provide a one-year allegation. I'm typically, in what I'm settling, putting whatever their allegation is, because that's what I'm settling, what they've alleged. Here's the various body parts that are alleged as injured and the code numbers, and then, of course, the address where the injury occurred. I've given here the list, the body part code list. You'll note it actually is 2 pages, switching back and forth, just as an example of how you pulled these codes down from the CWC website. There are some defects. There are certainly things that are not here. There are umbrella categories such as unclassified or other body systems. And you'll note that the extremities, upper and lower, are not identified as right and left. So that creates a problem. We do want to identify in our settlements which extremity was injured. And so we have to find a way to do that other than in the boxes on the form, which are sort of unforgiving in terms of giving you limited characters and only a certain amount of information put in there. So going on to claims information, applies to all claims with ADJ numbers. Specific injury, again, use the start date as a specific injury. Cumulative trauma, you provide a start and an end date. And again, as I just said, you stick to a one-year CT, customary but not necessary. Really, it depends, for purposes of settlement, on what's been alleged. In your compromise and release, you're trying to settle everything. So anything that's been alleged, you want it addressed at some point. Use the EAMS codes. Be aware that if you do not include a body part, you may not have settled injury to that body part. So it's very important that you be comprehensive and allege all the, settle all the alleged injured body parts. And again, EAMS doesn't specify right or left. You might want to clarify in the comment section that you're talking about the right arm or the left leg or whatever it is. The electronic form does not provide enough characters to provide an entire description in the EAMS body codes. And again, this is a problem when they came up with EAMS, is the things we used to write on settlement documents we can't write anymore in the form provided when you try and put the form together online. If you need to, you clarify in the comment section. That's what we've been doing. Now the next section, page 5, is the payments you've made. It starts with the average weekly wage. Again, if it's in dispute, you can write in dispute, but if you've agreed on what the wage is, then so indicate what your agreement is. If you write in dispute, the judge may ask, what's the dispute? We'll want to find out how you settle that dispute and use that information to determine if you owe something in addition to what you're paying in the settlement. Then you provide your payments. You'll also note that the forms tend to be one size fits all. They anticipate 1 period of TD on the compromise and release. They give you 2 periods on the stipulations. You may have paid 5 different periods. There are a number of ways you can handle that, and typically it's done in the comment section. I like to be accurate in providing the payments. If there are multiple periods, you can either list all periods in the comment section. You could list the first period and then write in the comment section that there were additional periods. Or you could put the first and last date of all payments in the form and then write broken periods or benefits paid during various periods in the comment section. For example, in the comment section, you might write TTD paid January 1st, 2012 to April 1st, 2012 at the rate of $400 per week, January 1st, 2013 to June 1st, 2013 at the rate of $400 per week, or TTD paid in broken periods, PD paid in a lump sum, you paid in a lump sum, various rates from a certain date to another date. And before we get into medical payments, one of the documents you can provide to the judge to explain these things is your benefit printout. And I believe many judges will require that. They do want to know if your benefit printout shows that you paid, particularly the permanent disability you're taking credit for, but also they want to know if there are any retro periods of TD that are owed that aren't being settled in your settlement. Under medical pay, you provide a lump sum. This is what we paid for medical payments. Typically, you shouldn't be including your med legal costs or your medical management costs, but really nobody questions that number. It doesn't become particularly relevant. In the past, there have been times, particularly when we had species penalties, where that amount, if for some reason a penalty was adjudicated later, the amount in the C&R was used as the med pay, and it burned the defendant who added payments that really weren't technically medical benefits. So here's the form itself. You look down at the bottom, the average weekly wage, the sections that provide temporary disability payments and permanent disability payments, and the rate and the total medical treatment payments. For unpaid medical expenses, if the claim is denied or you're making a nuisance value settlement, you can indicate medical bills are paid by applicant. Judges may question that. In most cases, under who's going to pay, I write per paragraph 8 below. And let's go back. You see down at the bottom of the page, I wrote per paragraph 8. That's all the characters that we can get in there. What I'm saying is this is going to be addressed below in paragraph 8. And then in paragraph 8, we include an explanation. You want to note the resolution of all liens in paragraph 8. Generally, EDD is going to sign off on your settlement with medical liens. I know in Southern California you need affidavits and so forth. We don't need that so much in Northern California. Representation that the liens have been resolved is probably good enough in Northern California. But they must be addressed. If the judge looks in EAMS and sees liens that aren't addressed, they're going to ask you what's going on with this lien, and you're going to have to deal with it. You can actually provide confirmation letters to show that the liens are resolved as part of your documentation if you want to do so. All right, we're getting to the next page. This is the page that talks about the settlement amount. Very important to do the math here. You start with the gross amount of the settlement. Then you have a section for PDAs, and it's very helpful. It resolves a lot of problems that we used to have with the old form, because you'll note you provide a number for PDAs, but it's only through a certain date, typically the date of your printout. That means that any PDAs you make after that date, you can still take credit for, because you've only represented that through the date of your printout, you've made certain payments. But be sure that's accurate. Also, if you are taking a credit for temporary disability overpayment, you're going to have to explain the basis for the overpayment, and remember that that credit is discretionary, so the judge may have some questions about that. The other sections are for things like a child support lien, liens for living expenses, EDD. There are cases in which you're deducting payments to EDD from the settlement, so you would want to put that in there. There's a question about whether you would put your payment for your Medicare set-aside in this section and deduct it. I typically don't do that, but I have seen it done. For attorney fee, I leave that blank. I let applicant's attorney write in the fee they're asking for, and then when you get the compromise and release back signed, you do the math and you provide the balance net to applicant. I've got some examples here under paragraph 8 of how to handle lien EDD. I typically write my agreement right in the C&R or do a separate stipend order that EDD signs and the judge approves. They agree to accept a certain amount of a settlement of their lien of whatever their lien is. If medical provider liens are resolved, identify the provider and note that the liens are resolved. You can put the amounts in, or agree to pay, adjust, or litigate, but avoid hold harmless language. The reason we avoid hold harmless is it has been held that if you hold the applicant harmless, you lose defenses that are unique to you. You only have the defenses the applicant would have. Medical necessity would be one, for example. But being outside the MPN is not a defense the applicant has. Only you have that. So you may have waived objection to medical treatment outside the MPN by holding applicant harmless. A lot of the judges don't know this. We have to educate them. They really want us to hold applicant harmless. They think what it means is the applicant won't have to pay. If we agree to pay, adjust, or litigate, we've agreed to take care of that lien, and I think that should be sufficient for the judge. As far as EDD, the best practice is to resolve the lien before you enter into your settlement, because if you're going to take some of the payments to EDD out of the settlement, for example, they should have been paid as permanent disability, then you want to do that in your settlement. You don't want to find out later that you should have done that, but you've already paid the applicant. And this is just what I said. That's the case that found that you couldn't assert certain defenses if you held applicant harmless with respect to liens. That's Baraha. All right, paragraph 7. This is just an explanation of what we just went through. You start with the gross amount, work through your deductions, be accurate with your PDAs. If you do not indicate that you've paid PDAs in your C&R, you may lose your credit for those PDAs, and there is the written-eyed case that supports that. So again, be very accurate as far as what you're claiming credit for. Be sure that's in the C&R. If you write subject to proof, that means you go back and say, well, whoops, we didn't pay what we said we paid, and we now have a printout that shows something better. Will it protect you? It's certainly worth a try. TD overpayments, again, this is discretionary. If it's a large overpayment that wipes out the permanent disability award, it will not be allowed. If it's a small amount because, for example, you didn't get word that they'd returned to work for a couple of weeks, or you didn't get the PNS report, the MMI report for a couple of weeks, you had a slight overpayment, that's probably going to be okay. If it's due to your error, the judge may not allow the credit, even if it results in a windfall for the applicant. There is a case that says if the overpayment is based on a retroactive PNS date by an agreed medical examiner and by extension a QME, after you've been paying, the primary treater has had injured worker TTD the whole time, unless your objection, when you objected and went to the QME, identified that issue, you lose that credit. It's a terrible case, in my opinion. It's wrongly decided, but it is the Court of Appeals case. It came out of Sacramento, one of our judges here. My response would be that when you object for any issue, the medical legal evaluator is by statute obligated to address all issues. That's why they call it a comprehensive medical legal report. You shouldn't have to know every issue in advance and make all the objections you could possibly make or get burned for not making those objections. So that criticism, just be aware of the case and the pitfalls in claiming overpayment. Again, there are times when payments are made and there are liens that are filed, typically living expenses and child support. These liens come out of the settlement. When the injured worker is represented, we leave that to the injured worker's attorney to resolve those liens. Sometimes we have to get involved with unrepresented injured workers, but that section on the form where we're deducting from the gross amount is where we would note the resolution of liens for child support and living expenses. And of course, you have to demonstrate that the lien claimant has agreed to these deductions, so you need some documentation there. Again, if the settlement includes payment out of the settlement to EDD, put it in that section. Leave the attorney fee blank. Let them ask for their attorney fee, and then let them argue with the judge if the judge thinks they're asking too much. All right, do we include a deduction for a Medicare set-aside? Again, it depends on how it's being handled. If an actual trust is being created with an actual trustee, which is very rare, then I might deduct it and indicate it's going to the trust. Typically, I leave that for an addenda saying that this settlement includes funding of an MSA and the annuity and so forth. If the applicant is self-administering the Medicare set-aside, it's probably best to solely rely on language in the comments section or in your addendum. And I'll tell you right now, we're going to go quickly over Medicare language. I know it's a big issue. Unfortunately, our clients all handle that issue individually, so it's best to check with your own organization about what your protocols are as far as the threshold for when you need an MSA, when you submit it to CMS, and the language and forms that you need in your settlement in order to settle with an MSA. All of our clients have different approaches there, and it just would be too difficult to have so many different approaches in one webinar. So the next section, the next page, indicates what issues are being resolved. There's an issue here about whether you should check all the boxes or just check the ones that you're settling. My preference is I only check the issues I'm settling because, once again, if I indicate I'm settling an issue, then the judge is going to ask what's the dispute and what's the range of evidence and how did you resolve the dispute. But be aware that if you don't check a box, you haven't settled that issue, and that can be very difficult, very dangerous. So a lot of people do check every box, and I typically have not seen the judges complain. But be ready for a question about whether or not you're settling or how you're settling that issue and what the dispute is. If you check a box, for example, earnings or employment, they really aren't in dispute. Now, the comment section, I don't know why they gave us such a short or small space. In a very clean settlement, you can just do what I've done here and write this settlement is based on the panel QME report of Dr. Fibes, rated by the DEU at 10%, provide the value of that. The judge can tell what the premium is on top of that by the gross amount of the settlement and therefore knows what you're paying for the future medical care and possibly the voucher. But most settlements are a little more complicated and you need a little more explanation, and sometimes you do need to go in the comment section and add an addenda. Again, both parties must initial all issues. If you haven't initialed those issues, you haven't settled the case. There is a case out there, it's a writ denied case, in which even in the addendum, the parties indicated they were settling a 132A petition, but that box was not checked on the C&R form. Very bad result. The WCAB held that the 132A petition was not settled by the C&R, therefore applicant was free to go against the employer independently of the C&R and go after the 132A. So be aware that you need to check every box and indicate every issue that's being settled. Again, this is what I just said. Some judges will inquire as to why you're checking every box. I think you should only initial the issues actually being resolved, but just be thorough and know what you're resolving and what's not. Obviously, the applicant or applicant's attorney has to initial their boxes as well. All right, the comment section is your opportunity to explain the basis for the settlement and clarify any points not clear. In the interest of time, I'm going to skip some of my samples here, go back and look at the webinar to look at the samples. But again, the key is to explain why your settlement is adequate. If there's something unusual, explain. There was an earnings dispute. The applicant produced some pay stubs, we had a weight statement, we resolved it for this amount based on a compromise. It could be as simple as that. There was a period where applicant was working at reduced hours, and so we paid wage loss rather than temporary disability. Whatever it is that is unusual, that requires an explanation, I would put it in the settlement. Sometimes when we submit these things, particularly if we're submitting them, e-filing them for a task for the judge to approve, I will write a cover letter explaining, here's how we came up with the settlement, here's what the reports say. Obviously give the basis of the PD, provide a string rating wherever possible, make it easy for the judge to evaluate your settlement. Again, will a percentage of PD in a C&R be sufficient to call that an award of PD so that later somebody can get apportionment? We don't know yet. But why not try? The question is, do the judges like to see the rating? My experience is, yes, they do. I don't see any reason not to put your string rating in there. If you have a DEU rating, you can give them a copy of the DEU rating. If you've rated it yourself, they get to see what you've done. They're far more likely to approve it. If they just see a number, they're going to ask how you came up with that number, unless in their head they can sort of ballpark it and see that it looks adequate. What about a denied claim? Can you still use Thomas language? We talked about this a little bit. Thomas versus Sport Chalet is a case which involves settlement of voc rehab. There's a good faith dispute, and that would defeat the whole claim. You could settle voc rehab. We don't have voc rehab anymore, so technically we don't have Thomas. But you can always write language, and I don't reference the case. I just write language saying there's a dispute about whether this injury occurred, and I use that in the same way that I would use a Thomas. WCAB could find no injury based on the testimony of employer witnesses and so forth. That, I think, goes just as far as a Thomas in convincing lien claimants that you settled to buy your piece and that they shouldn't necessarily expect full value of their lien. Explanations could also justify your settlements at nuisance value. For example, if you have a treating report that says 0 WPI and you don't want to go to a QME and you're settling for $5,000, you can put that in the explanation. What do you do when the applicant's not yet MMI? Can you settle your case? Judges often look sideways at these settlements. You use language that justifies the settlement. One, you could estimate the level of PD. Well, you better convince the judge that that's a good estimate. So that's a difficult one. But it can be done. Thomas type language, that's a perfect opportunity. So there is an employment issue here, which if resolved in favor of defendant would defeat applicant's claim. That justifies a settlement at a reduced value, even a nuisance type settlement if your defense is quite strong. Or, and this is language everybody should take away. If you don't take anything away from this webinar, this is the thing to take. There's one thing. Applicant does not wish to participate in discovery. This boxes the judge in. The applicant won't go through a depot, won't go to a QME. You could basically settle for almost anything because you can get their claim not necessarily dismissed, but you can get benefits barred after a petition to compel. And you know, if you've agreed with applicant's counsel, we're going to settle this claim. We're not going to go to a QME. We know what it's worth. Put that language in there, and you have an applicant's attorney there when you're walking through, or you make the representation that this injured worker does not want to go to a QME and does not want to go through a deposition if you haven't had one yet. And that will go a long way in justifying your settlement prior to MMI status. All right, this is a sample. I'm actually going to skip this sample because it's pretty complicated and it's rather long. It's from a real case. Go back and take a look at it. And I'm going to jump right into addendum. What do you include in your addendum? Now, judges do not like lengthy boilerplate addendums that basically are one-sided and favor defendants, and the applicant looks like they're giving up every right they have, the right to their firstborn child and so forth. We used to have these. They would settle all claims known or unknown, all FEHA claims, civil claims. They would hold us harmless on the MSA and everything else. This is what the judges don't like, and when the C&R form was revised, they were hoping to eliminate this. What this does not mean is that no addenda are allowed. I think there's a lot of misinformation out there. I heard a lot of rumors when the forms changed that, oh, you can't use addenda anymore. That's not true at all. If your explanation for the basis of your settlement is necessary, and you feel it's important to put in the comment section, and you don't have enough room in the comment section, you run it into an addendum, and you go on and explain. We paid 3 periods of TD. We paid a different rate because there was wage loss. Whatever it is, it's going to make the judge understand this is what you did and why you don't necessarily owe anything more than what you already paid or what you're paying in the settlement. Of course, if your addenda has provisions that the judge is not going to approve, they're not going to allow it, and they're going to ask you to strike that. And again, all injuries known or unknown, settlement of claims over which the court has no jurisdiction, settle all injuries to body parts mentioned in the medical record. We used to do this all the time. They don't allow it anymore. You need to spell out the body parts. Now, if you have a structured settlement, you can outline the terms of the structured settlement in the comment section. You simply indicate that payment will be made in accordance with the terms of the structure. Make the structure, the seed money, the annual payment, however it's structured, as an attachment so that everyone is clear as to how the payment's going to be made. MSA, again, every client is different of ours. Some require an addenda setting forth the requirements of applicants to self-administer, keeping receipts, depositing payments. This is technically what they're supposed to do, regular reporting to CMS. That's probably okay. The workers' comp judge will probably not approve language if it includes a hold harmless on the part of the applicant if CMS increases the MSA in cases where you haven't submitted it yet. Is anything required more than standard language? Often, when I have an MSA that's fairly routine, I just write, this settlement contemplates funding of a Medicare set-aside in the amount of blank out of the proceeds of the settlement. Applicant agrees to administer the Medicare set-aside trust. If it's been approved by CMS, that's probably good enough. If you're settling without an MSA, throw in that applicant represents he or she is not presently eligible for Medicare and not anticipated to become eligible for Medicare within the next 30 months, and that Medicare's interests are protected in the settlement. That if the applicant's willing to sign that, that's their representation. That's hopefully going to protect you against CMS or Medicare coming after anybody if this turns out not to be correct, or if they decide that they're owed money. If you're settling under the CMS review threshold, some people don't think a Medicare set-aside is required. Technically, it is required, but you don't have to submit it for approval. So just be aware of that. Again, each of our clients have their own protocols as to how to handle these situations. Technically, the MSA process is a voluntary process, but a lot of people are very concerned about the risk if they don't follow that voluntary process, and so they have various approaches as to how to interface with CMS, when to submit, and so forth. Be sure to get applicant's signature in front of either 2 witnesses or notary public, and that's the signature page, that's the notary page. Now, we're running out of time, but I'm going to very quickly run over the stipulations with request for award. The good news is this form is far more self-explanatory. You are admitting injury, typically leaving medical care open. All the periods and rates are specified, but the claim can be reopened within 5 years from the date of injury for new and further disability. When do you do it? Do it when you're still on the risk. The OCR form is similar to the C&R form, but our differences, page 1 requests venue information. Party information is essentially the same. Case information is very similar. Pay special attention to the description of injured body parts. I'm not going to go over every line. This is the STIP. You'll see it looks very similar to the C&R page. You also have lots of parties, and you have multiple employers, which you don't have on the C&R form, unfortunately. You get down to the bottom of this page, you've got the employee information, and you've got the case information and the body parts. Notice that there is a box at the bottom where you can list the body parts. They don't have that on the C&R form. That's going to control rather than filling in the spaces in each individual claim. So be sure you put in that box. And that box is the area where you now have an opportunity to write left arm, right leg, and so forth. Now, rule of thumb, in a C&R, your language is broad. You're settling injury to the spine. You're settling injury to the left lower extremity. Why? Because you don't want to have them to come back and say, oh, I settled my ankle injury, but not my knee injury. I settled my neck injury, but not my back injury. It's just the opposite in the STIP. since your medical care remains open, you want to be narrow. You want to say low back. You want to say left ankle, not lower extremity. That limits their ability to come back years later under the STIP and ask for medical care for a body part that's related to the injured body part, but maybe not exactly what you STIP to. And remember, medical care in the STIP is going to remain open for all injured body parts. This is just what I said. Construe it as narrow as possible. It will be construed against you if you write something in there and it's ambiguous, but it can be interpreted to include a body part. Probably will. And here's a terrible example. Well, I'm saying foot instead of lower extremity, low back instead of back or spine. Here's the real example. A stipulation to internal injuries was construed to include fibromyalgia. Is that terrible or what? I don't know who would stipulate to internal injuries. I mean, be very specific. Write high blood pressure, write diabetes, whatever those internal injuries are, spell them out. This was really sloppy work on the part of the defendant, and they got dinged for it because fibromyalgia, I mean, who knows what that is involved in terms of medical care that's going to be required now for that. Again, the language at the bottom of page 5 in that box will control, not the body part. Okay, moving on. Here's the temporary disability and permanent disability, like in the compromise and release form, but you will notice some differences. First of all, they give you 2 periods of TD. So if you only have 2 periods, you can put everything in there and you don't need to put comments in. You'll notice in the middle of this form the increase for failure to offer modified work or decrease for offering modified work for injuries prior to 1/1/2013. You will want to include that information to show when the rate increases or decreases and so forth. The next page is the same page for injuries on or after 1/1/13. So there are 2 forms. When you're pulling out your form, make sure you get the right one for the date of injury. Moving down the form, you check a box indicating whether an informal rating has or has not been generated. That's just whether you have a DEU rating or not. So if you didn't have a DEU rating, just check the box has not been previously issued. As far as medical care, we used to have 3 boxes. There is, there may be, or there is not. They got rid of maybe, unfortunately, because we used to be able to argue against providing medical care years later when we checked that box. Typically, you're going to check the box, there is need. It's very hard to convince a judge there really is no need. You better have that nailed tight in your medical record. Medical expenses and liens, there's sections for those. Again, leave the applicant's attorney fee section blank. Liens against compensation are those ones we talked about that get deducted from the settlement, but really they don't give you a section to, for example, provide medical treatment liens that you're resolving, so that's where I put that in. So there's a separate section for medical legal expenses and then a section for liens. And again, note the different forms for injuries on or after 1/1/2013 because we don't have the increase anymore. You have to determine whether the increase or decrease applies. You all, I assume, know how to check whether your employer has 50 or more employees and whether an offer of modified work was issued. Do be aware that once the offer goes out, it's the remaining permanent disability that increases. If you've made some large permanent disability advances, don't just go from the money chart that assumes 60 days and then an increase. You actually may be increasing less than what you would have thought if you had already increased or already paid permanent disability for more than 60 days. And that's exactly what this note says. The money charts that are out there assume P&S 60 days at the regular rate and then the increase or the decrease. In most cases, that's not actually how it works. All right, stipulation provides 2 periods of TD. We already noted that. Also note there is a section for the life pension. If you're settling over 70% or more, and then you're going to need a life pension. You'll note how much the weekly payment is. If you get a commutation and it reduces the payment, you may want to note somewhere that payment will be made per the commutation as opposed to the rate actually on the form. Is there a need for medical care? 99.9999% of the cases, yes. Even if a QME says no need for medical care, I had a settlement where I checked the box, no need for medical care. QME had said that. The surgeon said, come back and see me if you have any symptoms. That was enough for the judge to make me change it to, yes, there is need for medical care because the door was left open by the treater. All right, can you limit future medical care to treatment recommended by an AME? In Southern California, no. Maybe. In Northern California, no. But be careful, because this was done in a case, and later when they wanted to go to IMR, it was determined they had waived IMR because the AME was supposed to resolve that dispute. Again, the form distinguishes between medical legal liens and treatment liens. I always write medical legal all paid or will be paid per the medical legal fee schedule. Same thing, pay it, adjust, or litigate language, same as the C&R. Don't hold applicant harmless. True liens against compensation or living expenses and child support, maybe ETD. All right, moving on. The sections for the attorneys and for the applicant are basically the same as what we've seen before. Make sure it gets signed. There's no need to sign in front of witnesses or in front of a notary for some reason on this form. There's a section for other stipulations. You can use that section to provide the basis for your settlement. I think it's helpful. Also, always write on your stipulation that interest is waived if payment is made within 30 days. The C&R form has that written into it. The stipulation doesn't for some reason. So add that in. It's less important now that we don't have species penalties. The delay in payment is going to be the amount of interest. So 25% of the interest is not going to be a huge amount. No need to sign in front of witnesses or notary public. All right, now, something general about settlements. On approval of a compromise and release, findings an award or stipulations, and orders by the appeals board, it shall be conclusively presumed that any accrued claims for penalty have been resolved. This is really important. If there's penalties out there and they're not mentioned in your settlement, if they're not expressly deferred or reserved, they're gone. And this happens a lot. You get the penalty petition that's buried in your file, you settle that issue substantively, whatever the benefits are, they can't come back and argue that there's still penalties that were never resolved. If they expressly defer penalties, often you see this in stipulations and orders, for example, ATD, they'll say penalties are deferred. Later they can come back and argue their penalties. All other issues deferred are probably not good enough. You have to specifically identify penalties if you're deferring the penalty. All right, what do you include? We're really running out of time. The documents that we talked about, benefits notices, especially if you are not going to a QME, you want to show that you provided the QME information to the injured worker, copies of all the relevant medical reports, who objected to the PTP, notice of right to QME, wage information if there's a dispute, all the BU ratings, any proofs of service. There's a board rule now, you have to serve your proposed settlement on lien claimants, notice of potential eligibility for supplemental job displacement, and also your offers of modified work, settlement documents. I would provide benefits printout and wage statement if you have them. These are basically what we've been going over. Consider a cover letter with your C&R package if there's anything complicated that you're resolving. What do you do when you get an order suspending action on a C&R? You don't panic. It's not disapproving the C&R. It's just saying, I don't have enough information. Read it carefully and respond. Answer the judge's question. Provide the requested documents. Many times, you've done the right thing. You just haven't demonstrated it to the judge. And by doing that, you'll get your order approving. And with that, we are done. Just at an hour. So how about that for timing? Here's my information. Please feel free to email me or contact me if you have questions. Questions that we didn't have time for, we will answer outside of the webinar. I'll probably email and answer. And again, feel free to get in touch with me. We answer general questions. Everyone here in the office has a good deal of experience and is available to answer questions.